Salute you all. Thanks for being on and thanks for watching. So basically, today we are under the company law. And what you have to know, or what we are going to look at, we are going to look at the formation of a company, how a company comes to its, how a company is formed, basically. Under company law, we are looking how the formation of a company. Basically, we have there are like 4 procedures of formation of what? Of a company. We have the meeting of the promoters to the company. We have drafting relevant documents. We have organizing and payment of the relevant fees, and registration, which is incorporation of the company as the final what? As the final step. But nevertheless, let's look at how things are being done. Basically, first of all, the meeting of the promoters. That one we have seen that the company has to meet what? Promoters. These promoters help in developing what? The company, and that is a topic of its own, the role of a promoter in the company. Then secondly, we are going to talk about the membership of the company. However, when you look at the membership of the company, following section 4 of the Companies Act, that anyone or more persons but not exceeding 100 may, for lawful purpose, by subscribing their names to a memorandum of associations and otherwise complying with the requirement of the Act in respect of what? Registration. Basically, here they say that whereas that company is not private under section 5, it's public under section what? 6. So note that in mind. For a company it commences business from a date of issuance of a certificate by the registrar. That deals with the private. For it commences immediately, they give it what? A certificate. Is issued a certificate of what? Of business. That is section 22 of the Companies Act. But for a public company, incorporation and registration is not sufficient. But however, the company, the public company must issue a prospectus inviting the public to subscribe for its shares, and it must also obtain from the registrar a certificate of commencement of what? Of business, for it to start what? Business. Unlike a private what? A private company. And even before, the public company must conduct a statutory what? Meeting. What do they mean by statutory meeting? It must be held within 3 months from the date it is supposed to do what? To commence business. And 14 days before its meeting, all members are entitled to attend and vote in the meeting. They must be given a statutory report which must be signed by at least 2 directors, giving details of the status of the what? Of the company, following section 137 of the Companies Act. And failure to comply with such requirement, it can lead to winding up of the company or liability of payment of what? Of a fine to the registry. And for a private, for those things are not necessary. Doesn't need a statutory meeting, doesn't need a certificate of commencement of what? Of business. So note that in mind. And for a private company, it can start with only 1 director. But for a public, the minimum must be 2 directors, following section 185 of the Companies what? The Companies Act. So note that in mind. And also when you go further, realize that under the public companies, there must be fixed qualifications for one to be a director, and they must be contained in the articles of what? Of associations. You get? So note that in mind. That is for a public what? A public company. And also what you have to bear in mind, or what you have to put in mind, is that realize that under the articles of associations, or under the articles of association, basically, they must indicate whether the company is limited by shares or unlimited by what? By shares. Is there limited liability or unlimited by liability? Basically, note that in mind. They must also be indicated in the articles of what? Of association. Basically, or in the memorandum of association. Basically, there is what they call the Memorandum of Association as one of the relevant documents in the formation of a company. This memorandum of association is provided under Section 7 of the Companies Act, whereby that a company must have a memorandum of association which shall be printed in English and must state the name of the what? Of the company. State the company, whether it's limited by shares or guarantee, and by word limited must appear at the end of the what? Of the name of all limited what? Companies. And basically they also say that whether this requirement may be despised in the minutes are satisfied upon the application of the what? Of the company. Then also basically the memorandum of association, it must also what? Indicate the registered what? The registered offices, its location. It must indicate the objects for which the company is being made for. It must state the share capital, the nominal value of the shares in their fixed what? Amount. So note that in what? Note that in mind, or bear that in what? In mind. So it must also be dated. That memorandum of association must also be dated, signed by all the shareholders, indicating their full names, occupations, and addresses. It must be witnessed, and such witnesses must take their occupation and addresses. Then we also have articles of associations. Following Section 11 of the Companies Act, whereby they say that a company shall be lawful for a company to register an addition of its memorandum and articles of association, such regulation of the company as the company may deem necessary. The articles of association must show the purposes or the purpose of the company. Basically, its major emphasis, it shows the purpose of the company. You get? And basically what you have to know, membership of a company and a company, its membership. Following Section 47 of the Companies Act provides that all persons who may have subscribed to the memorandum of the company shall be member of the company, and when the company is registered, the name shall be entered on the register of members. You get? And we have two categories of people that are deemed members of the company. We have directors of the company who are supposed to take up qualification shares following Section 182 of the Companies Act. We also have individuals who have paid up for shares, and upon allotment and upon what? Subscription. So note that in mind. Then there's also a step that we have that is so vital, the step of registration or incorporation of a company. Incorporation, it is well as registering what? A company. First of all, under here there must be reservation of a company name. What do I mean by reservation of a company name? When you follow Section 36 of the Companies Act, they say that the registrar has wider powers to refuse the registration of any name which in his opinion is undesirable. You get? And following Section 37, the registrar in his own powers or on his own motion may direct a company's name to be changed the way he feels that it is misleading or it is harmful to the public. So note that in mind. Yes, and basically what you have to know, there are certain examples of undesirable names. One of it, names that the name of an existing company or a business entity that is already in existence. If the name is misleading, it is likely to have, the name is misleading the public. If it suggests some connection with with the government, if it is misleading the nature of the business, all those names are undesirable. And also if it is prohibited by statute following Section 38 of the Companies Act, provides that it prohibits trading under misleading names. You get? If also the name suggests connection with unlawful activity or offense, if basically that unlawful activity, for example, there There is a case of R versus Register of Companies, where two women formed what? A company from their personal services, and they used the name Prostitutes Limited. So the name was in connection with unlawful what? Activity. So not that in mind. Basically, that's some of the reservation of the company's name under incorporation. You must reserve a name, first of all. There is also the presentation of the what? Of the required documents before the registrar for registration. The documents, we have the Memorandum of Association that we have seen, we have the Articles of Association, the statement of nominal capital, the Declaration of Compliance, the list of names and particulars of directors and company secretaries, the prospectus of the company, basically. And also we have, after those documents, issuing the documents to the registrar, there's also payment of the stamp duty and registration what? Fees, and also issuance of a certificate of what? Incorporation. You get, they must issue a certificate of incorporation. Basically, not that in mind, they must give you that certificate. That is the private. For it starts business immediately. But for a public, it must also get a certificate of commencement of what? Of business. So not that in mind. So other than that, thank you for listening, and I wish you best of luck.